Welcome to INAN's Student. INAN Student is a platform for law students to come here and deliver a lecture on the topic of their choice. Today we have with us law student Mayank Kakade. He is going to speak on overview of Law of Limitations Act. He is from KES Shri Jayantilal Patel College of Law. So without wasting further time, I would request him to commence with his lecture. Thank you.
Hello everyone, good morning. My name is Mayank Kakade and I am a final year law student from KES Jayantilal Patel Law College. Today I am going to speak about a very important legal study, that is the law relating to limitation. This law is mainly governed by the Limitation Act 1963, which tells us how much time a person has to file a case, appeal or application in the court of law. It lays down the period in which the parties have to approach the court to claim their legal right. The court are given the powers to dismiss the plaintiff if it is filed beyond the time limit set by the Limitation Act. The Limitation Act has its origin in United Kingdom. To comprehend the Limitation Act 1963, we must first study its evolution over the period. The Limitation Act follows the principle of a legal maxim, which is interest republicant sit finis lithum, which states that the interest of the state as a whole, there should be a limit to the litigation, which means the litigation always comes to an end. It should not extend over the period. Another legal maxim, which is vigilant bus non thoritum sub veniam, which means law supports those who are aware of their rights. The law of limitation specifies the statutory time frame within which a person may initiate a legal proceedings. If a suit is filed after the expiry of the prescribed time, then it may restrict the plaintiff to bring a suit in the court. It is mandatory that a case is brought in front of a court within a prescribed time. The purpose of the limitation is, the purpose of the law is to prevent stale claims over old cases where the evidences and memory fails over the time. To ensure fairness between the parties, to bring certainty and finality to a suit, the suit must not go on and on. To promote diligence, meaning people must act quickly and they feel wronged. Applicability of the Act. The Limitation Act 1963 applies to all civil proceedings and a few specified criminal proceedings. The Limitation Act extends to whole of India. However, its application may be excluded by a specific law. However, limitation is computed. The Limitation Act provides different time periods for different kinds of suits like appeal, review, revision, application, filing, all of which are stated in the different schedules of the Act. The schedules contain 3 columns. 1. Description of the suit or application. 2. Period of limitation. And 3. Time for which the period begins to run. The court may follow these schedules very strictly and go beyond it if specified, mentioned by the law. The bar of limitation. Section 3 of Limitation Act. The Section 3 of the Limitation Act enjoins a court to dismiss a suit if it is an appeal or an application made after the elapsing of the specified period. Therefore, by the schedule, irrespective of the fact whether the opponent has set the plea of limitation or not, it is a duty of the court not to proceed with the proceeding even though the defendant has not raised an objection. The court can raise a suo motu objection over the case if the time has lapsed. Section 3 limits the time after which a suit or a proceeding would be barred. The right to sue and commencement of the running time for the purpose of the limitation depends on the date of the cause of action of the case. The cause of action is a fact or combination of facts that gives a person right to claim his legality. There can be no period of limitation for facts which the court are bound to perform. However, even if a time-barred suit is wrongly allowed, the judgment is not void. It is still valid unless it is appealed in the higher courts. In short, law's limitation act bars the remedy in the court of law but does not extinguish its basic right. It was clearly stated in the landmark judgment case of Bombay Dyeing Manufacturing Private Limited versus the State of Bombay. All India Rank 1958 Supreme Court case 328. In this case, the court said that even if the period of limitation has expired, the right still exists, but it cannot be enforced through the court. Extension of the time, that is doctrine of sufficient clause. Sometimes a delay can be excused. Section 5 of the Limitation Act states that extension of a prescribed period in certain cases, any appeal or application other than an application under any of the provision of Order 21 of the CPC may be admitted after the prescribed period if the applicant or the application within such period is filed. Delay in filing criminal appeal should be excused when it was enormously filed in a wrong court or there was a delay in obtaining the decree or the order of the and a certified copy of the said matter. But sufficient clause must be established to condone the delay by the appellate court. Application for the setting aside ex parte decree cannot be allowed without condoning the delay. In this case, no application was filed for condonation of the delay in filing a petition under Order 9R 13 of the CPC. What are the examples of sufficient clause? Include, let's find out, wrong practice or order of a high court which misleads the party. Genuine mistakes made by the party or the advocate. Wrong legal advice which is made in a good faith. Serious illness or imprisonment of the parties. Time taken to obtain a certified copy of a judgment is also a reason. But negligence or ignorance of the law is not a sufficient clause. In the landmark judgment case of Ramlal versus Reva Coalfields Limited, All India Rank 1962, Supreme Court case 361, the Supreme Court held that the delay must be explained day by day, and in R.B. Ramalingam versus R.B. Bhuvaneshwari 2009 case 2 volume Supreme Court case 689, it was said that sufficient clause must be interpreted liberally to promote the objection. Person under legal disability mentioned under section 6, 7 and 8 of the Limitation Act states that this section protects the people who can act for themselves, such as minor, insane person, a person of unsound mind. If a person is under disability, when the right of sue arises, they get an extra time up to 3 years after the disability ends. For example, if a minor's right is being exploited or it is violated, and if he is below the age of 18 years, that is the age of majority, then the minor cannot file a suit by himself according to the provisions of the law. Therefore, he, after attaining the age of majority, in the eyes of law, has the time period limit of 3 years to file the suit to claim his legal rights. However, the extension cannot exceed 3 years under section 8. Special exemptions. Section 8 states that Section 6 and 7, which provides extension of time for filing lawsuit due to legal disability, includes right of pre-exemption, time limit exemption, continuous running of time. First, right of pre-exemption. The rule mentioned under 6 and 7 does not apply to cases aimed at enforcing right of pre-exemption. Second, time limit extension. The extension of time provided by section 6 and 7 of the Limitation Act cannot exceed 3 years from the end of disability or a death of the disabled person. This means that even when the extension allowed, one can only extend the filing period beyond 3 years, not after the end of the disability or the death of the person. Continuous running of time. As per section 9, the Act, once the limitation period starts, it keeps on running and does not pause even if an incident occurs that might make it hard to file the suit. However, an exemption if a debtor is given control over the creditor's estate, though letter of administration, the time limit to file a suit to recover the debt is paused until the administration period is over. Example: if a minor's right to sue arises before he turns 18, he can still file the suit up to 3 years after becoming an adult. Computation of period of limitation. Section 12 to 24 of the Limitation Act. While calculating limitation, certain days are excluded. That is, the day on which the period begins or the incident occurs, the time taken to obtain a judgment, decree or a copy of the court order, time spent in a wrong court or a wrong jurisdiction is also excluded under section 14. Time during which proceeding was stayed by injunction is excluded under section 15. Fraud or mistake delays that starts the limitation until it is discovered. Section 17 of the Act. This ensures that a party is not punished for the delay occurred beyond their control. In conclusion, the law of limitation is not about time, it's about justice, certainty and responsibility. It reminds every citizen that there must be an exercise within a reasonable time that allows and helps only those who are vigilant. As the saying goes, the law assists those who are awake and not those who sleep over their rights. Thank you.
Mayank, thank you very much. And I would like to appreciate you that you have taken a topic which is a very complicated law which we have. Limitation Act is not like a very straight law which goes, there are a lot of ups, downs,
Yes.
ifs, buts. So I'm really happy. It was a nice overview of the Limitation Act.
Thank you, sir.
A small token from Hammurabi to you.